Felon in possession of a firearm. So in Louisiana and in the federal court as well, in the federal system as well, it's illegal for a convicted felon to be in possession of a firearm, right? We get a lot of felon in possession of firearm cases along with drug cases, along with with some kind of murder, or along with some kind of sex crime, along with some domestic violence, right? There's a weapon involved, and someone who has access to that weapon, dominion and control over that weapon, and we'll talk about that in a second, is charged with felon in possession of a firearm. So there are two kinds of possession. There's actual possession, which is I have the firearm on me, in my hand, in my pocket, in my waistline, on my ankle holster. I have the weapon in my hand, right? So I'm in actual possession. There's a second kind of possession. That possession is constructive possession, which means I have dominion and control over the area in which the weapon is found. So the weapon's found in my bedroom, and I have dominion and control over that room. The weapon's found in my car, and I have dominion and control over that car. The weapon is found between the back seat of the car, and I was the only backseat passenger in someone else's car. I still have dominion and control over the area. The gun is clearly accessible to me. I'm in possession, constructive possession of that weapon. Those are the kind of cases that we get, and it has to be fought, because what's not possession is mere possession. In the Louisiana law, mere possession is not sufficient. So just having a weapon in a car, now I'm the backseat passenger, it's your car, you're driving, and the weapon's underneath the driver's seat. I can't get charged with felon in possession, but I've seen it. I'm in the passenger seat, weapons under the driver's seat, I get charged. Your car. Again, mere possession, sure. Constructive possession, dominion and control over the car, not really. It's just mere possession, right? It's just the fact that it's in that area, right? Here's the other thing. I pick up a bag. I don't know the bag has a weapon in it. I'm carrying the bag. I get, stopped by police and searched. The bag's got a weapon in it. I don't know the weapon because it's not my bag. I'm carrying it to someone else. Again, that's not knowing possession. It's dominion and control, but it's mere possession because I didn't have the knowledge of the possession, right? I still have to have intent. I still have to have the intent to have the weapon in my hand. So this kind of granular analysis is what attorneys do. It's what criminal defense attorneys do. When we take on a case and we look at a set of facts, we go to determine, are these facts sufficient to prove the elements of this crime? And in the felon in possession of a firearm, this is super important. There's one other aspect that we encounter a lot in these cases, and that is the forensic science aspect, right? A DNA swab on a weapon, a fingerprint on a weapon. Those are the kind of things that are used to tie defendants into these weapons, and it's, of course, what we're very, very good at. I'm a qualified expert in forensic DNA interpretation in the district courts of Louisiana, and so we can look at that with a set of very experienced, very knowledgeable eyes and see, is this the kind of evidence that can be used against you? Is it powerful? Is it not? Can we challenge it? Can we beat it? Can we go to court and win? And really, that's the case. If you get caught up in a situation where you're a convicted felon and there's a weapon and you've been charged with being in possession of that weapon, give us a call. We will take a good and granular look at the evidence against you and see if we can beat that case.